footnotes and additional lines in your income statement and your balance sheet.
Okay.
So, yeah.
Okay. Any surprises for October that you want to share with us?
No, October appears to be very strong. I haven't seen any significant issues on the expense side. No, major leakage, major repairs. Again, we are compliant with some of the other things. But I'm glad you did bring that up. Yesterday, I did have a phone call with Moody's, and it was part of their annual surveillance call. But unfortunately, with John I Mpa retiring a few years ago, they haven't done an annual in a couple of years. So, off the record, my gut tells me they were sort of, catching up, and they were in sort of panic mode. The only disheartening thing of the conversation was that they reaffirmed our rating of A2, and they took us from a negative outlook to a positive. And I asked him, I said, I never remember being on a negative outlook. And that's when he sort of said, well, it has to do back in 2012 when the city had issues with the SEC, and we decided to take a different look from you guys. So what we decided to do was, there is this relationship between the two of you, and they use the word siphon from a cash standpoint, that we decided to look at the two credits as one credit and give them a similar rating. And so when I was looking at the report, I asked them, well, this doesn't really talk about anything related to the city today, so whose credit are you looking at today? Well, the answer was, well, we updated the city's credit back in February. Now that the city's doing better, we're going to let you ride on your own. It's like, wait a minute, that's not fair. So the long and short of it is that they reaffirmed our rating. They've taken our outlook from negative to stable. And I reaffirmed to them, listen, we're all about open disclosure. We have everything disseminated on the website. Art is available anytime. I'm available anytime. So I sort of missed John I Mpa calling me at 5:30 in the morning to talk about this, and he apologized and he said that he won't make it his mission this year to open a more direct line of communication with us, because all this had been done through the city. So I was getting an email saying, oh, by the way, you need to respond to this or this. And I had no idea what was going on. So they were very apologetic about that.
Typically, it's quarterly or semi-annual?
It's annually. They do an annual. Unless you're issuing debt, then you go through the whole process again.
Okay.
So, that concludes my report, unless there are any additional questions.
Any questions for Scott? Thank you, Scott.
Thank you very much.
All yours, Mr. Chair.
Great, thank you. Morning, everybody. I think we have to wait until like 15.
On voting items, you did.
On voting items,
Yes.
we get everything started. All right.
That was brief.
Well
You
done.
let her stay there. She's getting comfortable.
Hoping the sea will be warm.
Yeah, right.
Service awards.
Yeah.
Save that for later.
Yeah.
Okay. And I don't think I see Margarita here. She's running a little bit late, so we'll just move that to later. All right, so let's start with the approval items. First, we need a motion for the minutes from last meeting.
Second.
All in favor?
Aye.
Aye, that motion passes. And a meeting for the finance committee from last time, from October as well, sorry.
Move.
Oh, I didn't know we had that on the agenda.
There's no reports on here for approvals, if that's what you're referring to.
From last week.
Let's talk about the actual
I got it, we got it.
minutes from the findings.
We have to pass the minutes from last
The
Oh,
week.
I'm
minutes-
sorry.
the minute approvals.
I'll move.
I'll second.
Okay.
All in favor?
Aye.
Great. And item 2, which is parcel B.
Good morning, board. Orlando Dockins for the record. The item before you is the approval for, I'd like to correct something for the record on the agenda. It said Grand Central Partners, it's Grand Station Partners LLC. So I'd just like to correct that for the record. So the item before you is the approval of the ground lease between Grand Station Partners LLC, which was the selected respondent to our request for proposals for joint partnership or joint venture partnership for the redevelopment of parcel B adjacent to the garage. That was approved by this board several months ago. And this is the agreement that has been negotiated between our staff and the principals of that firm. In general, the terms of the agreement call for a 99-year ground lease with the possible option of an additional 50 years. The base ground rate, base rent will be $240,000 per year, with the contemplation of a 10% increase every 5 years beyond that. The respondent will be depositing $750,000 within 3 days of the execution of this agreement, of course, approved by the board, of which within 6 months, which is the due diligence period, $250,000 of that becomes hard, and we keep as they move along through the approval process of the project. The project focus contemplates that there'll be about 6 levels of additional parking for an estimated 355 spaces. Those spaces will be built at no cost for MPA, and these spaces will be owned unencumbered and fee simple by MPA for the duration of this agreement. In other words, there are spaces, the revenue generated from the spaces is ours, there's no sharing, and the land and the dirt under the project stays MPA's moving forward. The construction period construction must commence within 20 months of the effective date of this agreement, and they must obtain TCO 36 months beyond the commencement of their construction. And at the request of one of our board members, I'm just going to give a little synopsis of some of the numbers as it relates to this agreement and how we negotiated it. In order for us to arrive at what would be a fair annual rent payment for the ground lease, what is usually done in that kind of negotiation is you assign a value to the land, and then you apply what is called a cap rate, which is an assumed rate of return on that value. The assigned land value for that property for this exercise was $11,200,000, and we arrived at that number by reaching out to a real estate consultant that does commercial transactions in the CBD very often. And he gave both myself, Art, and other members of staff a level of comfort that as land is being transacted right now, a value of about $400 a square foot for the land was a good number to use. And we applied that to the size of the property to arrive at that number. So having done that is how we were able to calculate and negotiate to get to the $240,000 a year. So if we have that as a backdrop, and we contemplate the fact that we, as I've already stated, we're getting a $750,000 initial deposit or payment from the developer. They're building us about 355 spaces based on our experience, construction costs currently, and factoring in some soft costs, for the cost of engineering, architecture, etc. The value of that construction to us represents about $9.4 million. So just between the spaces and the upfront payment, there's a value of about $10,150,000. So you can see that that in and of itself is almost what the value of the land is right now. Beyond that, if we factor in that because of the nature of the project that's being built, which doesn't require any parking at all, and all those spaces, like I said, are built for our benefit and other revenues come to us, we then also did a present value calculation for the additional revenue streams that we'll be obtaining. One being from the additional income from parking that will be generated by those 355 spaces. With the help of operations, we were able to determine what we think is a conservative number that will be generating once those spaces are built, as well as a present value for the future payments we'll be getting from the ground lease. So doing a present value calculation for our expected additional income from the spaces, that has a present value of about an additional $20 million, and the ground lease has a present value of about another additional $4 million. So if we add up all the numbers, the initial $750,000, the value of the construction, and the present value of the additional revenue streams, this project has a present value to our agency of about $34 million. Having said that, we are asking that the board approve the ground lease.
Open it up for discussion.
Are there any questions for me?
Yep. Any questions for Joel, Joanne?
I'll move the item.
I'll second.
Moved and seconded.
Quick question.
Yep.
all the two proposals that were received, Rory, do you have any backup to those? Any details on those two proposals, or?
Well, I mean, we have the proposals that if anybody wanted to see them, we could present them. The matter of the selection of the proposals and of the respondent, that was several months ago, and, you know, discussion with regards to that was had. So, if there's a specific question, if I don't have it with me, I could definitely look at it for you.
Before we vote on the item, I know that there's some people from the folks that were selected and then folks that were not. So what I'd like to do is give you 5 minutes to each side, and then we'll open it up for questions for them if there's an interest in that, and then we'll take the vote.
Okay.
Go ahead, sir. State your name for the record.
Yes, my name is Bruce Fishman. I'm with the Fishman Law Firm at 9200 South Dadeland Boulevard, Miami, Florida. I represent North Miami Avenue Realty LLC, which is a Mana company. Mr. Mana, as I'm sure the committee may know, is a large developer on Flagler now and redeveloper of Wynwood. The particular item, an unsolicited bid, and I'll be just as narrow as I can because I have limited time, does not comply with 287-05712 in many ways. One, with regard to publication, it was not published, the notice was not published in the Florida Administrative Register. Two, with regard to the resolution 1402, which is the MPA's resolution, which requires publication 2 consecutive weeks in a newspaper. The only publication that occurred, to the best of my knowledge, and based on public records production from MPA, was once on February 9th of 2015. Therefore, as a matter of law, any approval of the lease at this point in time respectfully would be illegal without a republication. Additionally, the publication itself, the one that took place on the 9th of February, did not indicate the true date for submission of proposals, which was March 6, 2015. Therefore, bidders besides Mana, anybody in the public who would have a right to submit an unsolicited bid, were not properly notified of the end date, if you will, for submission. Additionally, making the approval of the proposed lease illegal at this point in time. Dealing specifically with the publication in the newspaper, the one that did occur, said that interested firms are responsible for visiting MPA's website to obtain and download crucial information. In reality, nothing was published on MPA's site. There was no crucial information in the public records production that came to us. There were other bidders besides Mana who had actually asked for this information, and Mr. Noriega respectfully, or someone from MPA, responded in writing that in fact there was no crucial information published. There are no special requests or requirements is the response that was given in writing to one of the other bidders. The statute 287 requires reasonable criteria for choosing amongst competing proposals. No criteria has been published, either in the advertisement, on the site, or otherwise. Quantitatively, MPA is required to determine the overall public benefit before approving the lease. And that has not quantitatively been done. And addressing that specifically, looking at Mana's proposal and ignoring even the other ones that may or may not have been submitted or ignored the opportunity to bid because of the illegal process of publication. Mana's proposal was for 460 parking spaces. The Grand Station submittal is for 350 spaces. The public benefit are the spaces for MPA. Now, I listened to the audio tape and read minutes of the prior meetings. Apparently, the basis on which the selection committee used for determining Grand Station versus Mana or anyone else was that Grand Station was willing to submit absolute ownership of the spaces. But legally, this is a lease. This is a 99-year lease. The only thing that can be granted is the right to use the space, or in essence, beneficial use. So the submission of the 460 spaces by MANA specifically stated full beneficial use to MPA, and the beneficial use of the airspace and other portions for the development for MANA. There were no restrictions. The construction was... What?
Got 1 minute.
Okay. The construction was cost-free. The interesting thing is, when you look at this particular lease, there are restrictions on MPA. MPA has now guaranteed that Grand Station, every unit owner would have access to one space, and if the space is released for more than 1 month, that they would have a first right of refusal. So the standards for all were not equal. So to sum this up, we request that the lease not be awarded, that MPA properly publish after setting reasonable criteria that are clear so that all bidders and the public can submit and determine and have the committee determine what would be a reasonable and acceptable unsolicited bid for these spaces. Thank you.
Thank you. Is someone here from Grand State?
Good morning.
Morning.
Robert Burlington with the law firm of Crawford Burlington at 2601 South Bay Shore Drive in Miami, Florida. I'm here on behalf of Grand Station. They're here as well, the architects, the developers. They're here to answer any questions. I think it's safe to say that every I has been dotted, every T has been crossed. This has been a year-long process. What I just heard from council has all been dealt with. It's been resolved. There was a protest period back in May for anyone who felt there was any impropriety to protest it. That didn't happen. It didn't happen because there has been no improprieties. And this matter is properly before you for approval today.
Question?
I have a question for, I'm sorry, I don't know.
Mr. Fishman.
We've been dealing with this now for a few months.
Yes.
And your concerns are that we didn't properly notice the meeting, yet your client responded to the bid. So are you speaking on behalf of all of the other respondents that could have been, or are you speaking on behalf of your client? Because he did respond.
Yeah, the answer is I'm speaking on behalf of both. The process needs to be legal in order for the result to be legal. If it's illegal with regard to MANA, it's illegal with regard to Grand Station, it's illegal with regard to all potential bidders. There were no criteria set, is another problem.
Okay.
You guys have,
Okay.
but I'm trying to address your
No, you
particular point as
did.
well.
You said that you're here on behalf of other potential bidders as well as your client. In the time that we have discussed this, it's been in front of the board a couple of times. Your client never came to talk to us, never, and I've talked to our staff before this happened. And your client actually didn't want to meet with anyone or declined meetings at the last minute. So I find it very interesting that he decides to come in at the last minute and then claim that we haven't done the procedure properly and claim that we are doing something illegal.
Can I
When
address
you've
that?
had all this time to reach out to us, all of us here were available to any of you to talk. And I haven't heard from your client or you. So I'm trying to figure out where this is all coming from, and I understand that you're going to give me the legal what do I want to call it? I'm sorry? Right. So thank you. So I wish you would have come before this board or reached out to any of us before today.
Can I address that? Because I
Absolutely.
actually have, Mr. Noriega will confirm that I've met with Mr. Noriega. I came to the last meeting, which was pulled from the agenda. without any notification to us, even though we indicated that we were coming forward. We put forth a public records request. I had Mr. Ziskovich, the architect, and others come and meet with Mr. Noriega. There's been correspondence back and forth with Mr. Noriega. So although I personally did not reach out, because I did not know it was procedure to reach out to everyone on committee, I certainly did, and we did, to Mr. Noriega. Now, just to add one other factor, it was basically told to us that if you do not do a joint venture with Grand Station, then you will not be considered. And that was what we were told. And Mr. Mana owns the real estate. He owns the 14,000 square feet of real estate on this parcel next to parcel B. Grand Station owns nothing. The ability to us to expand the spaces to 460 versus 350 is simply because we own the additional airspace and land. This is the reason that MPA wanted a joint venture. But there's no reason for us to joint venture. Mana is financially sound. He's developing all of Flagler Street. He's developing Wynwood. He's redeveloping Miami. Okay, yet he has been excluded, as others have, by this process and by the illegal publications.
And I'm glad that you bring that up, because as if you're saying that he owns all these other properties, he's financially stable, it would have been great to see that in the proposal that he sent the first time.
It
So
was.
that's all.
Sir?
Can I talk to the city attorney?
Yes.
Are you concerned about these arguments?
They are sound arguments, at least procedurally. Pablo Velez, for the record, Assistant City Attorney for the City of Manhattan. They are sound arguments, procedurally, and as far as our code is concerned, at the City of Manhattan.
So if we were to move ahead today, in spite of these arguments, we would be putting ourselves into legal difficulties.
It is possible. I mean, he has arguments he can make based on certain points. It is possible, yes.
Mr. Fishman?
Yes, sir.
You mentioned a provision, I think, in the RF.
If I may, I'm sorry.
Yes, Pablo,
I'm
go
sorry
ahead.
to interrupt.
No, please.
However, that being said, with respect to the sound arguments, there is also a protest period, and that's also a sound counter-argument, and there's a procedure with respect to protesting a potential award or recommendation for award that also must be adhered to, every bit as much as every other part of the procedure that the code provides for. So I just wanted to make certain that the board was well aware of that.
You mentioned, I think, in the RFP that there was a direction, or in an advertisement, there was a direction to send people to the website for additional information or information that would be pertinent to the request for proposals, and that you received a communication from Mr. Noriega saying that there was actually no information on the website that was pertinent. Is that my understanding of what you said?
Yes, it actually wasn't me. The Rolando Tapinas, sorry, my pronunciation of names is horrible.
We've called it worse.
On February the 18th, wrote back to Lee Hodges, and Lee Hodges was another potential bidder from Peebles Corp. Answering these questions. This was discovered for the first time during the public records response, which we just got a few days before this meeting.
If I may respond to that, if you need me to, Mr. Mitchell.
Yes, please, go ahead, Rose.
So as, Rolando County for the record, so as it relates to that, we do not do these kind of unsolicited proposals all the time. So the kind of advertisement that we put out in the notices are boilerplate, and say that because we usually have an RFP document. When people correctly, as Mr. Fishman said, went to the website, whether it be his client or several other people, they contacted me, in which time I told them in person and in writing that because of the nature of this, we had gotten an unsolicited proposal that they had access to that unsolicited proposal if they wanted to review it to get an idea of what was being submitted so that they can prepare their package. And in many cases, including Mr. Fishman's client, they requested the unsolicited proposal, which I proffered to them, and they had as additional information to prepare their package.
Okay. Counselor, have you had an opportunity to review some of these points that Mr. Fishman is bringing up, such as publication dates and stuff like that?
No, not specifics with respect to the dates that would have corresponded to the process. But I am aware of the issues that he made mention.
Okay.
I do have a copy of your notice, if I may, which is the only notice that we have.
I think we'll close the discussion. We have no discussion right now.
It was a question, and if anyone wants that notice, they can get it from me. It's okay.
I have it here. This is my only comment.
Any other questions?
Yeah. What I'm inspired by Mr. Mana's financial soundness and his contributions to Greater Miami. That's great for him. What my question to Pablo and maybe to Mr. Tishman is short of having an irregular notice process and short of having non-responsive or irresponsible bidders, which I have yet to see. Is there anything, Pablo, that would supersede all of that to warrant us not deciding on the motion as motion and second?
No, again, as I made mention of earlier, there was a big protest period. And no notice of intent to protest was submitted that I'm aware of.
So in the event,
Much less a protest itself along with the corresponding fee.
so in the event then that Mr. Tishman and Mr. Mana, Fishman,
That's okay.
sorry.
I'm owed.
Yeah.
I'm owed.
So in the event that
Get an alias.
in the event that there is some legal grounds to supersede our decision today, right? Then Mr. Fishman can proceed with whatever legal remedies he feels subsequent to the public bid protest.
Yes, however, usually when you proceed legally, they will look to see that you exhausted whatever administrative remedies you had available to you. In which case, they'll look to see if you have issues and if you made or communicated those issues via a notice of intent to protest and submitted the corresponding fee for such a protest. And then ultimately, just as important, if not more so, submitted a protest within the due time frame.
So for the record, Mr. Fishman, is there any reason why Mr. Mana waived that opportunity?
There can be no protest until there is an approval in a committee meeting of this particular lease, which has not actually occurred yet. It will be the vote today that is the occurrence. Till then, it's just talk.
I think we may differ on that, and counsel to the board can comment.
There's been no approval at this point.
If I may say, once there's a recommendation for award, that starts your period, your notice period.
We can respectfully disagree.
Well, that's per code, so.
We can respectfully disagree. And the requirements of 287 do not state that there is any protest period. It states as a condition precedent that there must be compliance with publication. And if there is no publication, then the process is illegal ab initio, which means from the beginning.
Any other questions? Because I have a couple.
May I comment briefly?
Sure.
Robert Burlington. Just want to,
Is it about that specific question that was being asked?
the city attorney commented on.
Okay.
I'll be brief, I promise. I just want to point out the obvious is that the party that did not succeed and is now contesting this by alleging some illegality and said there was improper notice they did receive notice, the best form of notice, which is actual notice, and they did present, and they were not successful, and they had the opportunity to protest. So to come in and challenge by basically saying we didn't know there wasn't an adequate advertisement is ironic, because they did know, they did come forth with a proposal, and Mr. Noriega can provide all the facts of that. In terms of the soundness of an argument, anybody can say anything, but this is all after the fact.
You're veering off of the question. Thank you. Go ahead.
Yes, just for the record, pursuant to City Code Section 18-104, Resolution of Protested Solicitations and Awards, we'll be looking at subsection A2, Protest of Award. I just want to read it into the record. Any actual proposal perceives itself aggrieved in connection with the recommended award of contract may protest to the Chief Procurement Officer. A written notice of intent to file a protest shall be filed with the Chief Procurement Officer within 2 days after receipt by proposer of the notice of the City Manager's recommendation for award of contract. In the case of the quasi-instrumentality agency of the MPA, the City Manager in this case would be the Executive Director. Further, also pursuant to that same City Code Section 18-104A, to C, a written protest based on any of the foregoing must be submitted to the Chief Procurement Officer within 5 days after the date the notice of protest was filed. A written protest is considered filed when received by the Chief Procurement Officer, and accompanying that protest in cases involving more than 25, excuse me, right, okay, the filing fee. The written protest must be accompanied by a filing fee in the form of a money order cashier's check payable to the city, and it must be for a certain amount, bare minimum, either $5,000 or 1%. Whichever of the two would happen to be the equal to. Whichever of the two is less. Whichever is the less, either $5,000 or 1% of the total contract value. That's just for the record.
Can I make one last comment?
No, sir.
It was addressing that for the record.
Sure.
There has been no notice of recommendation submitted to MANA ever on this, or published by this committee. Thank you.
Art.
Yeah, so this is a pretty consistent pattern. And so Bruce and I have met a couple of times, and David and I have met a couple of times, probably in the course of the better part of the year. And as I mentioned when I presented the item for approval relative to the award to the successful proposer, I referenced the fact that there had been a lot of communication reference to the property owner of the adjacent property, parcel B, all of which ultimately never materialized. So every time I had been approached about, we're going to set up a meeting, there was sort of go radio silent for months at a time. In this particular process, and there's been a lot of conversation, and I've made every effort, right, to try to bridge what in essence has been MANA's failure to focus on this site and focus on the redevelopment opportunity in Parcel B. This is pretty consistent with that. When the award was made, the fact that we're talking about this 4 or 5 months later, and I was very clear and with the board at the time we presented that I was going to try to put the two parties together and try to work something out, because I felt that that was a potentially advantageous opportunity. Ultimately, MANA, Moishe, to his own discretion, decided that wasn't something he was interested in. So, at some point, right, the process, and when you're especially when you're dealing in a public process like this, and particularly in this particular case, at some point you have to be both parties have to bear some responsibility, for the end result. And in this case, in spite of all the conversation, in spite of all the dialogue, we never seemed to really get anywhere and get any traction with it. And partly because, quite frankly, and I've had this conversation with them specifically, they are doing a lot in Miami. And I applaud Moishe for all that he's working on in Wynwood and certainly along Flagler Street. But I think what that's resulted in is a lack of focus on this project. And when you look at the proposal, and you look how vague it is in a lot of areas, and you have, and none of you were part of the conversation I had with them literally a week before that submittal was due, and they hadn't even started. So, you know, part of it, you know, ultimately, and Moishe, in my personal conversation with him, has never wanted to own up to the fact that he wasn't really focused on it. And he felt there was a sense of entitlement because he owned the property adjacent to it. And as much as I tried to bridge that gap and open a line of communication, quite frankly, I can't force it. And at this point, they can take whatever action they feel is deemed appropriate, post the recommendation, and I stand by the recommendation wholeheartedly. And in fact, it's reinforced by my interaction with them over the last year. Bruce is a very reasonable guy. I've had nothing but very pleasant conversations with him, and by the way, multiple people that are involved with Mana's organization, both internally and externally. And to be completely frank, it has been absolutely frustrating. So, you know what, at some point they have to be held accountable for their lack of real focus on this. And you know, I get it. You're doing a lot of things, you're acquiring a lot of property, you're working on a lot of projects, but that doesn't mean that we have to be in a holding pattern as a result. So that's sort of my closing statement on this. The board is certainly at their discretion to make whatever decision they feel or deem is appropriate, but I have been as frustrated by this as anybody else, and I've made a lot of effort to try to make it work, and quite frankly, it's just been unsuccessful.
Steve, you had one more?
Yes, I'm troubled by some of the things that I hear Mr. Fishman talking about, and equally troubled that there hasn't been a communication between Mr. Fishman and Pablo to the point where Pablo could tell us whether or not the issues that he's talking about are on point or not on point. So I feel I'm in the minority in terms of my colleagues moving forward with this, but I am going to vote no because I believe another 30 days for Pablo and Mr. Fishman to get together and talk about these issues without this cloud hanging over us is important.
Okay.
I think we have clouds in Miami all the time. I think that we've done our part as a board and our staff, and we have to be able to respect that process as well.
I'm ready to move forward too.
I have one last question. Do you guys feel like this was an illegal process?
No.
No.
All in favor?
Aye.
Aye. No?
Opposed?
Yes. No.
41. Motion passed. Next, do you want to do the...
What is parcel B? Building next to it. I mean, but where is it? Right next to it. No, I mean, what's the building? Oh, okay.
Yeah, that's good.
That's it? That's the meeting?
No, just that.
Yeah.
We still have,
Yeah.
you're still.
I hope so.
Commissioner, you want to come up? I know we kind of had you in the front end of the agenda, but I wanted to, you know, as pretty consistent with our practice over the years, you know, we rarely ever get an opportunity to sort of say thank you to our elected officials for their dedicated service. We've done it pretty consistently in the past, but sometimes it doesn't always work out that you have to still have the opportunity for various reasons. In this particular case, I really wanted to just extend my gratification. Commissioner Sarnoff has been somebody that, because of the nature of our business and how much of our business occurs within his district, more so than any other commissioner, this particular District 2 seat has always been one that has been really important to us in terms of our ability to function. And we've had some really good relationships in the past, and our relationship with Commissioner Sarnoff and his entire staff, because he has, by the way, a great staff. He's very easy to work with. And they're very engaged throughout sort of our sort of footprint within that district. And he has been an advocate on a lot of levels for a lot of what we've tried to do. He's been very supportive of it. We certainly want to wish him congratulations on the next phase of his life, or sort of a warm send-off. I know he's, in the last few weeks in interacting with him, he's I think looking forward to his next phase, and professionally and personally. And so, we wanted to present you sort of with a token. We do this on a pretty regular basis. I don't know how much change you're going to collect, but this might be an easy way to get people that come visit you now in your law practice to pony up a little change, loose change on a regular basis. It just says Commissioner Mark Sarnoff, a true friend of Miami Parking Authority, wonderful public servant, November 4th, 2015. Anybody else have anything they want to add?
We appreciate all your support. We really do. Thank you.
So, first off, thank you, Miami Parking Authority. I certainly don't think I would have gotten up this morning at 8:30 for anything else. Just having spent last night, it was a truly weird night, and it will be a weird day the rest of the day. But, just a word about you guys. Probably the most professional board that I've had occasion to interact with. Certainly the best director I've ever interacted with. And any of you will know that I said that if I was mayor, which I'm not going to be mayor, Art Noriega would have been the city manager of the city of Miami. So you really have you're very fortunate in having such a honest, forthright, and director. What I mean by direct is nothing ever grabs Art. Art grabs everything and understands everything and crunches everything. And as a board, it's great to have somebody that really gets it, and somebody who never allows something to come at you at an angle. It's always on a straightforward basis. So, as Art would say, he's in the business of parking, and that's the business that you're in. Parking will inevitably be the solution, in part, a large part, for the traffic congestion problems in downtown Miami. Stay very engaged in that solution. I know Art had this idea years and years ago of circling the city with parking garages so that then we would circulate through it. I think now is the time to implement. I want to personally thank him for everything he's done in the Grove, because, and this board as well, because you could have very easily taken a different tack than you took in the Grove. And the Grove is difficult. Case in point last night. It's a difficult place to be, but you're going to make the Grove a better place, and you're going to add parking at an amount that it's never seen before. And I didn't anticipate getting up at 8:30 this morning, and certainly didn't want to. But to get this is really my honor and my privilege from this board and this director to probably have my swan song, which is probably right now, to say just thank you all, because it's been an honor and a privilege to serve as the District 2 Commissioner. And I know that you probably have heard this before because it's the ECO, but truth is the daughter of time. And however a person does is a product of time. And I think we all played a significant role in building Miami. We all wrote a chapter in the book, in a very new book. Somebody once said, "Are you sorry you left New York?" And I said, no, I would have been chapter 3,632 with a footnote there had I stayed. But in Miami, you get to write probably chapter 4 in what will be a great chaptered book, and to have a place and a role in there with Art, with this board. I want to thank you all for allowing me to do it, so thank you. Thanks.
Item 3, amendment to the